in an hour and a half, I can't really do it any sort of justice, but I'm going to give you as complete an explanation of the process as I can. Those of you that know a little bit about it may learn a little more. Those of you that know a lot about it, this will be repetitive or maybe a refresher for you. And then I really want to talk with you guys about the challenges of doing this work with your clientele, because it is challenging for many, many reasons, which we'll talk about. And then at the very end, and I want to make sure that I have time for this because this part of it I think is critical, is I want to go over the sample intake conversation with you so that as you take these calls, you know what questions to ask these people, what to be looking out for, and what to be talking about with them. Sound like a plan? Okay, so I'm going to screen share. Do you guys have the materials separately from my screen sharing them? Hold on. Lena, do they have them? Can somebody answer my question?
I do not. I didn't receive anything that I'm aware of.
Okay. All right. So that's cool. I will screen share with you. Let me just close up all my little windows here so I don't give you all my attorney-client secrets. I was already at 9 o'clock. I had everything closed, and then, all right. So I want to share screen one. Let me have it. There we go. Okay. Can you guys see my screen now? I can't see you anymore when I'm screen sharing.
Yes, we see it.
All right, thank you. I can only see who's speaking, which is me, and I don't really need to see me. Okay. All right, so let's get past this. Okay, so what is collaborative divorce? These are the sort of the highlights, the features. It is a no court process. Some people call this no court divorce. It is a team approach to decision making, which involves 2 lawyers, 1 for each person, a mental health professional, and a financial professional. The feature of the process is interest-based decision making. So what's most important to each person post-divorce? And if there are children, of course, we focus on the needs of the children. So do you guys have a good understanding of interest-based decision making? Yes, no, maybe so. Who wants to talk to me about that? Anybody?
Give us a refresher. Nobody
Okay.
okay.
There's a kind of a hokey story that it gives an example of this in a way that's very understandable, but I'm telling you, it's a little hokey. So the story is that there are 2 children, which might not be hokey in the time of COVID, who are just going to town with one another, fighting. They're sick of each other. They're hungry. There's 1 orange in the fridge, and they both want it. They both want the orange. And so they come yelling, screaming, and mom, she's a good mom, very carefully cuts the orange so that's exactly in half. And she gives 1 half to one child, 1 half to the other child. Of course, the good mom, she might say, one child, okay, who chooses to cut the orange, and the other child gets first pick of which half they get, right? That makes them really want to try to cut it evenly. But had she engaged in some conversation about interest decisions, she would have asked girls, you know, okay, hold on. Why do you want this orange?
Your voice is cutting in and out.
Okay. I think it's probably internet as opposed to technology. Let me see, I can turn myself up a bit. Is that better? Okay. Thank you for telling me that.
Can you recap? We got mom cutting up an orange.
Oh, you didn't get anything. Okay.
You were like in and out computer sound.
Okay. The 2 girls come to mom, and mom says, what is going on? What's the problem? We're hungry. We want the orange. There's only 1 orange. Mom carefully cuts the orange in half, making sure the halves are equal, and gives 1 half to each child. Or if she's a creative mom, she might have one of the kids cut the orange and let the other child choose first which half he or she wants, right? And that way that kid tries to cut it as even as possible. But had she spent a little bit of time and asked the kids, hey, what's going on? She may have learned that one child was indeed hungry and wanted the orange to eat. And the other child was not really so much hungry, but she had been hanging over the fence talking to Mrs. Jones next door. And Mrs. Jones had offered to make that child her very, very favorite yellow cake with orange icing if the child could bring her the zest from an orange, the peel, not the inside. And so had mom had that conversation, each child would have gotten more of exactly what they want. One child would have gotten the entire inside of the orange to eat and enjoy for her snack. And the other kid would have gotten enough zest from the entire orange to go over to Mrs. Jones's house and help her make this delicious cake. So that's interest-based decision-making. You try to get underneath what the parties are saying they want, because what they're saying they want is not necessarily what they really want. Does that make sense? Okay, next feature, the process requires, I would change this actually, not only financial transparency, but transparency across the board and cooperation. So if the parties aren't willing to be transparent about, let's say, transportation challenges when they have their kids on their time sharing, you know, if they want to put up a front that they can handle it and they don't have any problems, and you know they're going to argue for this time sharing schedule that they know they can't really fulfill, then we're headed for a problem. So the parties have to be transparent with one another. There are no decisions made outside of team meetings. So there's no lawyers going back and forth. Sometimes the parties will make decisions outside of meetings and you really can't, you know, prevent that. And if they're both happy, that's okay. But the point is to stop the positional back and forth between the lawyers. So you guys know every time something gets told, the story changes just a little bit. That's the nature of conflict storytelling. If I tell you a story of a conflict that I've had, when you turn around and recount that amazing story or outrageous story, you're going to tweak it just a little bit. You're going to emphasize the things that stuck out to you. And it's completely subliminal. It is not on purpose. But that really screws up things in family law negotiations when the client tells the lawyer tells the other lawyer goes back to the client, and we're trying to make decisions. And so we stop that in collaborative process. And all issues, the last feature of the process is that all issues are resolved. So parenting, child support, time sharing, equitable distribution, spousal support, all those issues are addressed. In addition, we try to address as many of the emotional issues that as it's appropriate. So sometimes we have mental health issues with one person in the case. We can't solve those issues. But if there are emotional issues between the parties caused by prior trauma or prior conflict, working with the mental health professional can really get some peace and resolution around those things, which then enables these folks to step forward into their co-parenting relationship, having healed from whatever happened during the relationship. Okay, thoughts, questions? Anybody want to say anything? No? All right, let me see if I can see more.
Pam, really quick question for you with regard to what you just said about involving kind of the mental health, you know, therapist in the process. In terms of your experience, and do you feel like also involving parenting kind of coordinators for those high conflict or highly contentious disputes is also, you know, favorable in those sorts of situations?
Yes, so built into the collaborative process is an ability to invite what we call allied professionals onto the team. And so frequently it's a parenting expert, although many of the mental health professionals that are trained collaboratively are also parenting coordinators. So
Okay.
they bring that to the table, but sometimes you may need an extra person. More common is to recruit an allied financial professional to work one-on-one with one of the spouses, usually the wife still, that has been what we call the out spouse. That's a not very nice term, but that, you know, doesn't know anything about the finances, has never paid a bill, doesn't know, you know, so they may need a little bit of support in addition to the financial neutral. So yes, we do have allied professionals that come in. The team tries to bring whatever support the people need to get it done.
Okay.
So very flexible, kind of no limits on that. Okay.
Okay.
Okay, moving
And
on.
and
Oh,
Pam, really quick question.
yeah.
We don't know with the desktop portion, it's showing a copy of your desktop, but we remember it was sharing your full collaborative divorce, kind of your template before, but it disappeared.
So what are you seeing a slide that says core principles right now?
We're
No.
seeing your desktop screen.
Oh, well, let me just take this right back over here then. I moved it because I didn't want to be looking sideways
Oh, okay.
at you guys, but that's okay. There we go. Can you see it now?
Yes.
Okay, I'm just going to move my camera over here, and then I can do two things at once. Okay, I'm going to put my desk down. My desk goes up and down, so I can adjust. Okay, so core principles of the collaborative process. As we said, number one, your situation is resolved outside of the courtroom. Number two, your attorneys cannot represent you if you abandon the process and choose litigation. This causes a lot of folks, a lot of lawyers, to reject the process because they feel like they're going to be losing clients. And that's an unfortunate framework or perspective to have about it. It's kind of rare for cases to fall out of collaborative process, actually. And when they do, typically not every issue is still left to be litigated. We're able to resolve either the equitable distribution or the parenting plan or the alimony, you know, and then you're sending them to litigators with just a narrow thing that needs to be tried. But what's more is you're sending them with all the discovery done, because we've had this financial transparency, we've had this financial neutral collecting all of the financial information. And so really the case is almost ready for trial if it falls out of collaborative. But that is a core principle for the reasons that Dayton and I spoke about, that, you know, you can't have one foot in the collaborative room and one foot on the courthouse steps. It just doesn't work. Core principle number three, everything is on the table. So we look at complete financial disclosure. We look at workplace or career impacts, which traditional divorce certainly does not take that into account. We look at social and lifestyle, which again, traditional divorce doesn't, other than, you know, the lifestyle factor in the alimony analysis, which is probably not a factor in the cases that you guys are dealing with anyway. You know, that's not a part of traditional divorce. And then we look at other legal, family or childcare issues. And so to me, kind of the linchpin of the collaborative process is creativity and option building. And so that's why everything is on the table. What works for one family may seem absolutely crazy for another family. And that's because every family is different, and every family needs to structure this in a way that works for them and their kids. Core principle number four, all parties and needs are considered. So again, it's just really an inclusive, there may be grandparents. You could add a grandparent piece here, which, as you guys know, doesn't come into play in traditional litigation. So the summary of the process right down here, you establish the framework, which is sort of what I've just talked to you about. We put a team together. There are 4 professionals on the team. You know, the professionals agree on the process. Then we gather information. So the gather information is partly financial and partly interest-based. So the first thing that happens in a collaborative process is each person meets with the mental health professional alone, not together. The mental health professional is not there to counsel these people or give them therapy or anything like that. The mental health professional is there to help them figure out their interests so that when we're doing interest-based negotiation, we know what interests we're trying to meet. And so the approach of the mental health is very, very focused on that. This is a forward-looking process, and the mental health coach really asks folks to look ahead and imagine what their lives will be like when this is all over, and tell us what's most important to them. So there's financial information, and then there's interest information. The next step is that those interests, the information that's gathered, is shared. And typically we've got a whiteboard, and at the first meeting, we ask the couple to take turns telling us what their goals and interests are, and we write them down. Oftentimes there are common goals and interests, which is a beautiful thing. We're able to say, wow, you guys already have agreement on something. You agree that, you want what's best for your kids. You agree that you both want to be financially stable after this divorce. You kind of start to build right there. But more importantly, that whiteboard becomes sort of the North Star for us. So as we are brainstorming settlement options, if it doesn't meet one of those interests that we've got on the board, we know it's probably not a good option, unless they want to change their goals and interests, which sometimes happens. But it really is our North Star. It really helps us deal with difficult people who are not yet in the place of wanting what's best for their spouse. It helps us say, yeah, but Joe had this interest up here that it was kind of his number one interest. And so this option doesn't meet that interest. So this option may not be one that is going to work for us. Can we build on it? That sort of thing. I always say you don't know a good option until you hear a bad one. And so when we're brainstorming, we let folks put all options on the table. We do not react. We try not to react to options in the moment. Oftentimes, an option that you may have a gut check to as the process goes on kind of bubbles up as the one that may be the best one, or maybe with some tweaking, pulling pieces from other options. So it's a very dynamic process. I think it was Jonathan who said that, the counselor kind of runs the show, which is a little bit true in that the mental health professional is charged with holding the process for everyone, lawyers included, because sometimes the litigators who have become collaborators fall into old habits, and they become postural and adversarial, and the mental health needs to say, all right, everybody, we're going to take a step back here. And they set the agenda, they run the meeting, they make sure that we're dealing with all agenda items and things like that. And then we, finally we come to an agreement. We pick the options that are the best, and we write it up, and we're done. And you've got an uncontested divorce at that point in time.
Pam, really quick question. Towards the beginning of the process, and we're talking about the mental health counselors, are there any nuggets of wisdom or tips that you have for kind of encouraging clients to kind of overcome that fear of kind of sharing things with strangers that they think could potentially be used, against them, so to speak, in court? So if it didn't work out for whatever reason, like, how do you get that client over that hurdle?
Yeah, that's a great question, because one of the things that we know is difficult is explaining this to clients in a way that they understand and getting them to buy in. And so the times that collaborative cases fall apart is when someone thought they were getting one thing and they get into it, and that's not at all what they're in, and they're not capable of being collaborative for whatever reason. They don't want to cooperate, they're too angry, for whatever reason. And so, it's really the core of why I'm here, is to help you guys understand this well enough to be able to explain it to clients in a way that they are making a very informed decision. Because it's so frustrating to get into a case and have a client pop up and say, well, I didn't realize this is what we were doing. I'm not into this. You know, you've put in a lot of time and effort at that point already. And so one thing we have to be very, very careful about is presenting this as a panacea. This is not a perfect process. It doesn't solve every case. It doesn't solve every problem. It is not easy. It is not kumbaya, we're around this table and we're happy and we're going to play nice in the sandbox. You know, people still have emotions. They still get angry. They still express that anger. Maybe they express it inappropriately. The difference is we've got a professional in the room to say, okay, Monique, it sounds like you're really angry. And what you said may have really just hurt Julian's feelings a lot. So let's pause here for a minute and see what's really going on, right? But to get to your specific question of people being fearful, and I know because I've done several pro bono collaborative cases that these clients have a very specific viewpoint of professionals in the process. And it usually is a distrustful perspective. They've had some bad experiences. They've been, you know, treated poorly. They've been duped maybe. That, you know, there is a huge trust piece with these clients. And so the best you can do is assure them that nothing that happens is admissible in court. No matter what, no matter who's involved. I mean, it is as black and white as it can get. The lawyer can never be hauled into court. The therapist can never be hauled into court. The financial can never be hauled. None of us. It's kind of like, this won't mean anything to them, but it's kind of like mediators. You know, if you get a subpoena as a mediator, you fight the subpoena and no judge is going to make you testify. It's a confidential process. And in a minute, I'm going to talk about, we actually have a statute in the state of Florida. So that governs all of this. And so again, that's not going to be helpful when you're doing boots on the ground talking to these folks. But I think the more you mention private and confidential and, you know, wouldn't it be great if no one knew what was going on in your personal life? Because no one will know what's going on if you choose collaborative. Nothing gets filed with the court that shows what's going on. It all stays very, very private. So in Seminole County, they do not even require the parties to file financial affidavits. The lawyers file an affidavit saying, we have the financial affidavits, we will keep them on record if there is any post-judgment issue, but they are not filed with the court. I am working really, really hard to get that same thing over here. It's hard with the judiciary, as you guys probably know. They're pretty sclerotic and they don't change easily. But right now they're having a financial crisis. And so I'm approaching it in terms of, hey, I'm filing all my family law cases in Seminole County because I don't have to file financial affidavits. You guys want those fees? Let's do the same thing over here. So that's a long answer to your question. And hopefully more of what we're talking about will touch upon that as we go. I'm really glad, you know, everything is in divine order and happens as it should. And the fact that I've done so many pro bono collaboratives before I had the opportunity to talk to all of you as a group is really helpful because I've had the experience of working with just the situations you're asking about. And it's helpful. It's helping me to talk to you about it in a way that I know is real, that it, you know, this is what is happening out here. So in case there was any doubt about how it's different from traditional divorce, here's a little chart about how things are different. So these are the axes that we talk about: control, adversity, cost, timetable, experts, privacy, voluntary communication, and court involvement. So the control piece, and as you're talking to prospective clients, a lot of them really key into this control piece, that you have absolute control over what happens with your life. You and your spouse, that's it. There's a great video, I'll send it along to Lena or Martha, they can share it, of the grandmama of collaborative, and she takes a piece of paper like this and she says, Here's what you tell me when you come to my office that you want me to know that you want to be considered in your divorce, okay? Here's how much I actually take in and understand and process and can put in any kind of way. Here's how much I can put in any kind of pleading or discovery or anything like that. Okay. Here's how much actually comes into evidence in a trial. Here's how much the judge may hear of what is put into evidence. Here's how much is actually relevant to the issues in front of the judge. And here's how much the judge actually takes into account when making a decision. So, and this is pretty accurate, I gotta say, having litigated for 30 years. So that's their alternative, is that a judge is going to control what's going to happen to them and their children. And a judge is going to make that decision in a vacuum, pretty much, not knowing you, not knowing your history, not knowing your children, and not loving your children and caring about your children the way you do. So that's one piece of it. Adversity, as I said, this is not a panacea. People are angry, people are hurt, it's not easy, but the team makes sure that there is respect at all times as we move forward. As we know, that's not what happens when people are in litigation. It gets very, very difficult. Cost is not a factor here in the pro bono realm, so I'm going to skip that. Timetable, the couple decides how slow or how fast we move along. Some people want to do it quickly. They want to have a meeting a week. And if they can get all their homework done in that time, the team tries to accommodate that. Some folks, it's overwhelming and they want to have a meeting a month or a meeting every other month. It takes between 3 and 5 meetings to resolve the case. In the we really try to get that 3 meeting mark just because
You're
a lot of our
breaking up again.
Okay. Well, I haven't moved. I haven't done anything. What's the last thing you heard? Any better now?
Yeah, you
Much
just kind of
better.
pivoted maybe 10 seconds ago, so I'd go back 10 seconds.
Okay.
Okay, and Pam,
Yeah.
I also did have a copy of the presentation that I forgot to send out. I've emailed it out to everyone, so if you can multitask and pull up your emails, you should have the presentation now also.
Okay, thanks, Lena.
Uh-huh.
I was saying that some folks want to move quickly and some want to move slowly, and that's up to them. It takes about 3 to 5 meetings, we know, to resolve most collaborative cases. In the pro bono arena, we really try to shoot for the 3 meeting mark, just because we're asking a lot of our volunteers to jump into a 5 meeting commitment. And if the couple does their homework well, we can get it done in 3 meetings. So that's the other thing, is that there is a burden on each person, each client, to do some work. They've got to come to these meetings prepared. They've got to gather the financial documents. They've got to, think about their parenting plan ahead of time. They really have to participate in order to make it work in a reasonable amount of time. Okay. Privacy, we talked about that. There is absolutely nothing that is disclosed in a collaborative. Collaborative is voluntary. Nobody's going to force them to make an agreement. If they reach an agreement, it's entirely up to them. Communication is a very interesting piece of collaborative because the clients are allowed to communicate freely with both lawyers if they want to. So, I may be in a collaborative case where, for whatever reason, the other lawyer's client and I have created a bond of some sort, who knows why, and they may have a question that they don't, they would rather ask me than their lawyer. Totally fine. Again, transparency. Everybody knows that's happening. Everybody's copied on all the emails. So it's very open communication. And a very open communication between the professional team. So the couple knows that mental health professionals, they share with the team what they've talked about, right? What their goals and interests are, what they think the hurdles are going to be. You know, sometimes the team say, you know, Pam is not really in reality here. You know, she has an unreasonable expectation about AC. And so that is all made known up front. There is open communication across the lines. Okay. Okay. Benefits of collaborative divorce. Quickly, I think you guys have figured this out. We address more than legal issues. We address emotional issues, enabling the couple to make better decisions about what's best for everybody. Hopefully, during the process, they learn new skills for more effective communication, conflict resolution, and everything. And that's because the team is modeling that for them as we go through these team meetings. And sometimes there can be some real healing as a result of the kindness and respect shown during the process. That I've seen many apologies extended at the end of a collaborative process. I've seen many transformative exchanges between parents who leave feeling very differently about one another than when they started the process. And that's, you know, that's the gold standard. So overall goal, every family has a support to make rational choices to maximize the long-term financial, emotional, and
Pam?
health. Yes.
It sounds like you're cutting out again. Maybe we can all pull up the presentation, and if you stop sharing, it'll probably stop making it choppy. Yeah, let's see if that works.
See what happens. Okay. All right, so you guys are getting CLE, so we have to talk about the law. So there is much to our delight in the collaborative community in Florida, a law called the Collaborative Practice Act, Florida Statute 1.5. And it is just laid out, you know, everything I just told you. So you see on the third subpoint, privilege, disclosure, and confidentiality. So you can tell your concerned clients that there is a law that prevents anyone in the process from disclosing anything that happens. Okay? So it basically just lays out the terms, how a process begins, how it ends. Are you guys hearing me?
It's going in and out.
Let me try microphone. Can you hear me now?
Yes.
Okay, let's try that. I have a couple of different microphones. I'm sorry. The statute is just a roadmap. You have to enter into a contract. It says what the contract has to say, how a process begins, how a process ends, what happens if there's already a proceeding going in court, what happens, how do we get that stayed, and there is a process for that. And then it provides, again, the privilege. So any clients who are concerned, you can tell them there is a law that prevents disclosure. Serena's suggesting that I call in. That might not be a bad idea. Is it clear now, or do you guys want me to call in on the phone?
It's much clearer now, actually, with the new mic, but we can use that option if it.
Much clearer.
Okay, so if it breaks up again, we'll just use the phone. I've had a lot of technology issues this week. I don't know, you know, as more people are getting comfortable with Zoom, more people are using it, and it isn't there. But in any event. Okay, I want to talk, there's a lot more in your materials than I want to go over because I really want to get to the practical pieces of it. And you guys can read, you can look at your materials, but just to talk about the role of each person in the process, because it's quite different than the person's role in the process in a traditional divorce. So coming back over here so you guys can see me. Hold on. Okay, the role of a collaborative lawyer. Educate and counsel the client, manage conflict, build and assess options, guide interest-based negotiation, and then prepare, of course, the legal documents. Okay, quite different from a litigator's role. We consider ourselves settlement specialists. That's what we call ourselves in a collaborative process. We are your settlement specialist that's going to be working with you. We advocate for you, you know, at the same time that we are being collaborative. We don't abandon our advocacy role. We just fulfill that role in a very different way. We focus on a healthy transition for this family, not on the deal or what you're going to get or what you're going to give. We really And there's a saying that fair in collaborative is what you pay to get on the bus. We don't talk about fair, we talk about acceptable. What's acceptable to you to move through this transition and restructure your family in a constructive way? So that's what we focus on. We focus on the needs of the children, obviously. To be successful, you lawyers who are thinking that you may at some point get into a collaborative case, and I hope all of you do, you have to move from debate to dialogue. You have to be able to constantly ask yourself the question, what is it like to be you right now? Right? You have to get outside of yourself and try to get into the conflict and the person. You have to move from, this is what the law provides. The law says, you know, this is what's about you. We don't say that in collaborative. The law is absolutely irrelevant. If someone wants to agree to pay, you know, double the child support that the guidelines call for, they do that. I mean, that's their perfect right to make that agreement. We don't talk people out of their agreements. We inform, certainly we inform our clients, but we don't base decisions on the law. We shift from a win-lose to a win-win. So I like to say, sometimes we can make the pie a little bit bigger before we have to cut it up. And that's where the financial neutral comes in, especially when you're dealing with these pro bono cases, because here's the God's honest truth about it. And when I go around the state and I give talks about access, I say this and people kind of don't like it, but the God's honest truth is if you have money, if you have enough money or excess money, you can solve a lot of problems, right? If you don't have enough money, the problems that are easily solvable in a traditional collaborative case with a middle income or higher earning family become much more difficult. And so you have to see, can you make the pie a little bit bigger before you have to cut it up? We detach from the outcome, right? It's such a paradigm shift for lawyers, and some can do it and some can't, but we cannot, it's that child support example, right? We cannot be pulling our client out of the room and saying, what are you doing? You don't have to pay that much. What are you thinking? Here's what the guy, you know, we don't do that. It's not our life. It's not our money. It's not our outcome. Okay. Okay. The role of the mental health professional. Any questions about the lawyering piece of it?
Really quick question, Pam, in terms of the financial portion, us over here at the helpline, a lot of the times we get calls where people are just unwilling to share their finances, or the clients know for a fact it's a complete underestimation of, you know, that adverse party. I know it's not necessarily adverse in the collaborative world, but how do you get around that hurdle of making sure like everybody's bringing this to the table, and what they're bringing to the table is actual and factual based on
So I'm going to skip over the MHP. We'll come back and I'm going to go to the financial, the role of the financial neutral, because that's how you do it. The financial folks that do this work, they're, you know, CPAs or financial planners. They, you know, they have some career in finance, accounting, and they're also collaboratively trained. And so if someone brings them, you know, some pay stubs and some tax returns, they can very quickly see like, okay, wait a minute, something's missing here. This isn't adding up. There's income over here that I'm not seeing over here. As they start to look through bank statements and credit card statements, they just have the ability to spot these inconsistencies. And they work with the clients offline. This doesn't happen in a team meeting generally. They call them up and say like, hey, you know, I'm a little confused about this. And someone who is trying to pull a fast one typically doesn't get away with it, because the financial neutral can figure it out pretty quickly. We all know there are some people out there who are bound and determined to lie, cheat, and steal, and they're good at it and they're going to get away with it, right? And, you know, you can't really get too hung up on that. Oftentimes the other client is the one to say like, oh, no. When we were together, you know, he brought home $1,000 a week in cash, right? Where's the cash? And so, we can have that conversation, and hopefully, people are there for the right reasons, and they have enough trust that nobody's trying to screw them over, that they're going to be transparent. That's the hope. But you raised another point, and I'm going to digress here for a minute, because this is of keen interest to me and all of us that do this work, and that is, you've got the client who qualifies for services, and they come into a collaborative case, and we put together a pro bono team, and we get into the collaborative process, and we find out that the other party is making, significant money. And I don't have a good answer to this problem. I can tell you that I personally, and it is a very personal choice, I think, that people individually have to make. I personally feel like one member of that family needs the help, and we're not going to deprive that person of the help they need because this other person has money. Other groups around the state that are doing this feel quite differently, and feel like when they get into a process, if there are significant assets, they're going to expect some payment for the professionals. It may be $10 a meeting, but their feeling is that unless people have quote unquote skin in the game, they're not going to be cooperative and work hard and do what they need to do to make the process successful.
Does that apply even for, like, let's say victims of domestic violence, where there's been a lot of, that financial abuse as well? Is that the same position? Okay.
There aren't many robust programs doing this in connection with legal aid organizations. So I don't know the answer to that. I don't know if any other group has encountered that. I know that, for me, although I personally would choose to still provide the services for free, sometimes I alienate one of my other volunteers because they're feeling, especially like the lawyer that's representing the person with the money, they're like, yeah, this doesn't seem fair. And so as an organization, collaborative folks are struggling with this because we want to provide access, but we also want to be fair to ourselves, and we don't want to burn ourselves out. And we haven't really figured out how to deal with that. I don't know if any of you have any thoughts about that. I'd be delighted to hear them. My personal experience has not been that clients are not appreciative. I have not had the skin in the game problem. My personal experience is that every person that I have helped has been more than grateful, more than gracious, appreciative, appropriate, has worked hard, and come prepared. Now, having said that, we do have very strident boundaries. So if someone doesn't show up for a meeting, and we've got 4 professionals who have set aside 3 hours of their time and are sitting there, and that person doesn't show up, they're done. There are no second chances, because I would never get volunteers again if I abused them in that way. And that's all explained to the couple right up front, and the way I do it is to say, you've got 4 professionals who are donating time to you. Were these professionals receiving their normal hourly fees, this process would be costing about $1,000 an hour. And you're getting it for free. And all we ask in return is that you respect our time and that you participate fully and come prepared and do your homework. I've not had anybody, not show up, or, sometimes a car will break down or a kid will get sick, or, things happen. But, those are some of the challenges that we're having with the pro bono cases. So, you guys are really in it day in, day out. If you have any thoughts or suggestions or questions about it, I would love to have a little dialogue about that right now, if anybody has anything to share.
Do you think a process that is similar to when people are filing in court and they have to apply for, indigency status, and you see at the top it says, well, it's a one-time $25 administrative fee, and this goes into this big pool of money, and it's to basically keep this process rolling? I don't know if something like that could be applied.
Yeah, that's a good idea. Yeah, oftentimes we don't have financial information about the other party when we get started. So the way it has been working is I get the collaborative questionnaire from Lena that's all filled out, and I have information about your guys' client, contact information, income information, all that stuff. And all I know about the other party is their name and contact information, right? Because you guys don't know. I mean, there's no way you could know. And so one thing I've thought about is if the person wants to come into the process, you know, then having a conversation about finances and is there any ability to pay anything? Because a lot of times these guys, I hate to be sexist, but it is usually the guys that are making money and the women that have been, you know, financially locked out, or a lot of times they know exactly that they're getting the deal of the century, and you know, they know that you don't usually get divorced, and you don't usually get this kind of divorce without paying anything. And you know, I think some of them would be willing to pay something, actually. Yeah. So something to figure out. I mean, we don't want to violate any of your guys' protocols in the process. You know, we're balancing a lot of institutional interests and stuff here. So we have to be careful about that and how we might structure that.
And even through like the Florida bar, you know, sometimes there's that little checkbox at the end that says, hey, if you haven't done your pro bono, you know, commit to these different organizations,
Yes.
maybe including that. Maybe.
Yeah, that's a good idea. That's a really good idea. Anybody else want to talk about that at all? Thoughts about it? There was a chat question I saw. Use a scheme similar to the child support schedule. That's a great idea, Julian. Julian, the 5 out of 5 rock star, has some good ideas. Okay. That's a really good idea. I would need to work more with the powers that be over there to make sure that we're not creating, you know, problems from your mission perspective and nonprofit status and all that stuff. I don't know enough about it to even speak to it. So I sort of jumped over the MHP to talk about the financial neutral, and I want to talk just a little bit more about what they do, because you know, usually lawyers in a divorce case are poring over bank statements and paycheck stubs and running child support guideline calculations and all that stuff. In a collaborative case, the lawyers don't do any of that. The financial neutral does all of that. And so I don't go back behind the financial neutral and review. I trust when we come to a meeting and a financial neutral has a spreadsheet for me that it's accurate, that they have the backup documentation, because remember, that's their career. They're used to having backup documents for any numbers. They've got to tie it in, right? Those tie-ins. And so what happens is it becomes absolutely, you know, magically efficient, because one meeting will be devoted to equitable distribution, let's say. The financial neutral will have put all of the assets and liabilities on a spreadsheet. We'll have some scenarios about how to equalize them that make sense, so that we're not splitting up too many accounts and things like that. And they've gone over it with the client ahead of time, and they've sent it to me and the other lawyer ahead of time, and we've gone over it, and maybe we've gone over it with our client. So everybody is ready right out of the gate at that meeting to start making option building and making decisions. So that's what the financial does. They, you know, they have to have some personal attributes as well that lead them to be comfortable with conflict, that make them able to talk to people who are in crisis and struggling and upset. And so it takes a special person. And I can tell you that frequently the financial, if it's the right personality, sometimes those folks settle the case in their office. The clients just bond to them and like them, and it's really quite something what can happen. Their job is to educate their clients, and so they have to be a little bit of a teacher as well. They have to be very patient. They have to teach the clients, you know, about their financial, educate them to make smart financial decisions. And then backing up to the MHP, as I said at the beginning, this is not therapy for these people. This therapist is acting as a divorce coach. And sometimes I call them that. People can understand that. This is your divorce coach. This person's going to help you get through this very hard process. They're a resource for you. So they give voice to the children's concerns in the process, kind of like a guardian ad litem. but they won't necessarily talk to the kids unless the kids are older and that's necessary. But they do give voice to the children's concerns. And the goal there is to facilitate the process. As I said, they run the meetings, you know, calling the meeting to order. Here's our agenda. Here's what we're going to talk about. They jump in if somebody's misbehaving or not being collaborative or getting too angry or too emotional. They step in and do the magic that they do. I can't do it, but they can do it. I'm always so happy to have them there. So, you know, they create an atmosphere of healing and dignity for these people and respect. So this all sounds great. How does it work in a pro bono context? And I've touched on a little bit of that, but I'm going to turn to that now in a little more detail. Okay, I'm on page 14 of the materials if you guys have them. So the first piece is to identify appropriate clients, and that's why we're here having this conversation today. It is, I think I'm going to speak for Lena, but she can jump right in if she wants to. I think it is our hope that by having the helpline folks trained or familiar with this and giving them a script, that we will capture more cases. Because we want more collaborative cases. We want families to benefit from this healing process. And so number one is screening for domestic violence. And we talked a little bit about that earlier. I know that you guys have plenty of domestic violence training. I've had a fair amount of domestic violence training. And so we know that there are many different flavors, right? There's coercive control, there's actual physical battering, there's financial control, you know, there's all sorts of flavors. And so again, I personally do not want, unless there is actual battering, physical harm, I don't want domestic violence to be a disqualifier. Because I think one of the chat questions was, what about people who are being submissive and willing to settle too quickly? One place where that can be addressed is in a collaborative process, because both the mental health and that person's lawyer are going to understand and see that this person is just saying yes because they're afraid or they want it over with, and even the financial too, because as I said, the financial, their goal is to educate. And so remember, the team is there to support and uplift the family. And so we are going to support and uplift that person to make decisions in their children's best interest. And if we see someone just rolling over, we're going to stop. We're going to stop the meeting. We're going to convene outside. We're going to check in with that person. Often what that looks like, I've had this happen in most of these cases, the mental health steps outside with the person who's rolling over. And they go to a separate room and they have a little conversation. And the mental health will either come back with the client and say, we're good to go, or they may say, you know what, we're not good to go today. This is not, we're not in a place where we can make good decisions. And you know, we would then stop the meeting and reconvene at another time, or we might move on to another subject matter. You know, sometimes these folks are strong on some things and weak on others. It's not, you know, there is no typical situation. So my personal feeling is that more than any other way that people get divorced, this process could prevent a woman from being steamrolled and could make sure that she is making decisions in her best interest and that she's not making fear-based decisions. Now, I mean, I have had times where I didn't know, the client didn't disclose, or a man, thank you, Julian, I'm not trying to be sexist, really, I'm not. I have had situations where we didn't know the extent of the problem until we were in the process. You know, one or the other client would say, like, I can't leave this building because I think he's got a firearm in his car and I'm afraid. And you just have to roll with it. You just have to do whatever you have to do to take care of the person who is afraid and upset. In that particular case, actually the party who had the firearm and the temper, his lawyer was great. And his lawyer had a conversation with him, sorry, it wasn't him, outside, between the meetings and said, hey, do you have a gun? And they had enough rapport where the guy said yes or no. I think he admitted that he had a gun. And he said, look, you can't bring that to these meetings. You can't even be in the car. You can't do it. And he got an assurance from the guy that he wouldn't do that. And he felt comfortable that the guy was telling the truth. And we were able to move on. Having said that, we never put that woman at risk. Anytime she left a meeting, she stayed behind until the other person was long gone. In their car, gone for at least, and we would actually walk outside and look up and down the block and make sure he wasn't anywhere around. But what happened, and what we usually see happens, is because of the process, the respect, the kindness, the threat level really comes down pretty quickly to where by the end, this person was really not afraid anymore. I mean, I'm sure that's not the case in every case. I've worked with a lot of domestic violence victims, and I know that some, they're going to be afraid forever, and with good reason. Again, this is not a panacea. It's not, but it's better than the other options. It's better than letting someone get so frustrated and so angry in a litigation process that things spiral instead of calm down.
Pam, a quick question with respect to that. Even if there's a highly volatile DV situation, just like with mediation in the courts, like sometimes the mediation coordinator will make alternate arrangements and have people separate rooms. Could that process work even in collaborative divorce?
Yes, I have done that. Actually, it wasn't a pro bono case. We had an armed security person in the lobby of the law firm, because the scared spouse felt that if there were a security presence there, the spouse who made her afraid would not misbehave. And we positioned them so that the security person was in the middle, and there was a conference room over here and a conference room over here. And the doors were not even in eyesight of one another. You had to go around a little jog. And we brought in the batterer and put him in, or the person who we thought could be violent, put him in his room. He did not see the other party come in. He didn't see where we put her. He had no idea. I mean, he would have had to be running through the whole law firm to find her, and he never would have gotten past the security guard. So that's one solution. In a pro bono case one time, I was able to secure a room in the courthouse so that everybody had to go through the security in order to come in. Of course, that was pre-COVID. I mean, now COVID, everything's by Zoom. We have done collaborative by Zoom. We are doing collaborative by Zoom. So that might be the safest way, actually. Just in talking about that, thinking about that, even without a pandemic, doing something by Zoom with someone who has a domestic violence history is a lovely, elegant solution to that problem. So, another silver lining in this cloud of COVID that we have. Yeah. So we got to screen for domestic violence. That's number one. But I don't want it to be a disqualifier. And if anybody has any questions at any time, just call me, say, hey, I've got this couple, here's the situation, is it even worth sending over? And of course, again, I don't know what your institutional guidelines are, and I don't want to run afoul of any of that. But what I'm saying is the collaborative team is willing to work within a case that there are allegations of domestic violence, depending upon what they are and what the history has been and the personalities. Okay. The second hurdle, and you're gonna hear it in the little script that we give you, has to do with both spouses being available and willing to participate. So where I've seen a problem is I call, the way it's working now, I get the information sheet and I call the other spouse, and as you can hear, it's really hard to explain what collaborative is in 5 or 10 minutes. but I do my best. And they are like, yeah, I think I might like to do that. The hard thing is, do they really know what they're agreeing to, and are they going to follow through? And there's no way to really know that. Hopefully, if you guys are screening and then we're screening, we're going to get better at it. But what we know is that some people that say yes, I think I touched on this earlier, don't mean it. They say yes to a free lawyer. They don't understand that there's a certain way and making decisions in a certain way. And then we get into it and they're just being so, it's almost like they have oppositional defiance disorder. I mean, it just, you know, and then we have to sort of have a little reckoning and say, like, this is not how this works. And if you want to continue, you know, you really have to decide and commit. And that's going to happen. No matter how good our screening is, that's going to happen. We know that's going to happen, and we're prepared to deal with those little disappointments along the way. Again, you know, luckily, I guess my experience has been that most people that say yes mean it, and we have a great process. So we need to prioritize cases with children, because those are the families that benefit the most from collaborative, for sure. So that would be our preference, is to prioritize cases with children. Paternity cases are fine. It doesn't have to be a dissolution. We deal with paternity all the time. And then the sample script. So let me see if I can find that. Here it is. Okay. Let me move it over here. Do you guys have the sample script for Helpline? Can somebody tell me a little bit about the how do you guys work? Tell me about your typical day. What happens? I don't know anything about what you do.
All right, so we are kind of the nucleus in the firm. I call us the emergency room, Pam. So essentially, everyone who calls in for legal advice, they kind of go through us first. We perform the full intake, and we provide the general legal advice from a gamut of topics, of course, family law, but a range of other topics as well.
That sounds like a really hard job, you guys. My hat's off to you. That sounds like a really hard job. Yeah, interesting.
Thanks, Pam. So what we do from there, we kind of, as you alluded to earlier, if the client basically qualifies for additional services or extended services, we will send them to pro bono, or send them to the family law unit or our consumer unit or the other several units that we have. So it's kind of like a streamlined kind of process. When they call us, we give the general advice, and either we can include that advice at the end of the call, we refer to that other respective unit, and we welcome them, of course, to call us back throughout the course of their litigation, if they are actually in litigation. Some are not.
Okay. So if you send them to the family law unit, what happens there? What's the next step?
So generally what happens there is the family law unit, I'll use injunctions as an example. So they will reach out to that client and provide extended services for that particular client. So it may include representation. It may include helping draft, the pro se petition for the injunction. So that sort of thing, because their focus is, primarily domestic violence per our funding.
Right.
Let's say, for example, we had a consumer issue, some sort of foreclosure issue. We give same thing. We give the general legal advice. We send to our consumer unit, and from there they offer whatever extended assistance or services may be available to that client at that time.
Okay. So are we imagining that you guys would, one of your options for people who call into the helpline would be to refer them to this collaborative program, or would they have to go to family unit and then come to the collaborative program? Do you know?
I would believe it would go straight from us to the collaborative program.
Okay, great.
Or it needs to come through pro bono, so that we can send it, because we have to track that time and assign those attorneys to the case. So you would do it what we do in pro bono now with the closed cases that you guys send us is we have Iris recontact them in Volusia County. She does the initial screening for collaborative. And then I forward that on to Pam, and she says, yay, nay, it's a go, and puts the team together. So I think that it would just make sense to continue to do the referrals like you do. And then in your subject line said, screen for collaborative, or, you know, seems to fit the criteria for collaborative, and then we'll move it from there. I think it just makes sense to continue to do your referrals that way, so you don't have to think about it. And some kind of way pro bono doesn't miss a case that needs to be assigned to pro bono because it went straight to the collaborative.
Lena, can I ask a question?
Sure.
If we get a referral from a community partner, and it is, you know, typically we're getting those as domestic violence cases, and sometimes those domestic violence cases don't involve physical violence. There is the coercive control and other things, and the community partner still refers them to us as a domestic violence case. Are we in a position in the family unit to also throw that case in as a possible collaborative case?
If you've screened them and they meet that initial criteria, you would send it like the same way. What we're asking, what is better for us, if you get that case, are you giving them advice, the case from the community partner? Are you providing them with legal assistance up front?
We try to, for everyone that we get a referral from a community partner is getting some level of service, yes.
Okay, what you need to do is then close that case. If you've done all you're going to do with it, close that case and refer it to pro bono. We will do for collaborative screening, and if we can screen that case, if it fits in the collaborative, we assign that case, we reopen it as a pro bono case, we just reopen it and go from there. Otherwise, we're back and forth with having to send it back to you to close. And so it just makes sense to send it to us closed, and we can reopen it. It's the same process with the helpline.
So just to take it one step further, right? Going through that process, I close it, I send it for a possible collaborative designation. Is it possible that then that, because Serena mentioned, you know, pro bono attorney on one side and a family unit attorney on the other, does that then circle back around to me to possibly be the collaborative attorney?
That's all possible. That we have not worked out. But if the collaborative comes in that way, we would definitely have a staff attorney on that side. So I don't know what Serena is going to do with that. I don't know what we're going to do in-house with that. That is something that we've got to work out. But you guys, in order to participate in this, you have to be collaboratively trained. And I'm sure Pam will talk a little bit about that. There's some training coming up. The next one is in January, Pam, I think it is.
I think there's one at the end of August. That might be a little quick turnaround, but, and I would need to check with those folks and see if we can get a discounted rate for you guys,
Yes,
which I
like we
feel
did
like we
before.
can, but
Yes.
if we've missed the August one, yes, January would be the next one. Yeah.
Right.
And are there
And it's being
shadowing
done
opportunities
virtually.
in the meantime?
Yes.
Absolutely. That's one of the reasons why we love the pro bono work, is because it enables me to invite inexperienced collaborative professionals to, we ask them to be note takers actually, because notes are taken at every meeting and disseminated to all participants. And it's great if you're participating in a meeting not to have to worry about taking notes. And so, yes, we have a note taker at every collaborative case, both full freight, you know, high asset and pro bono. And so once you're trained, even before you're trained, you could be a note taker if you want to be, just let me know. And yep, we offer lots of mentoring opportunities. Sometimes I'll put together a team of completely inexperienced people. I try not to do that because it can get challenging. But if I do that, then I stay on as a mentor. a mentor to the whole team, and I help everybody. But usually I just stay on as one of the lawyers if I've got 3 other inexperienced professionals, because I just don't want it to get sideways. But yeah, lots of opportunities.
Great, thank you.
Yeah, I mean, listening to you guys, and again, it's not my place, not my, to tell you how to do your job. But my goal, when Lena and I talked about this, was to get more cases. And it seems to me that
Pam, are you still with us? I think you froze.
if at the helpline level, you guys can put a note. Oh, yes, I'm here.
All right.
Am I back?
Great.
Okay.
You're back.
From my perspective, when I talked to Lena about this, the goal was to get more cases into collaborative process. And so just listening to this dialogue between you guys, it sounds to me like what would be really, really helpful to the pro bono folks is to get, the documentation that says appropriate for collaborative. If you guys have done that screening and you've made that determination, that would help them not forget to do the collaborative questionnaire, or it's just everybody's so busy, and it's it's an extra step, and I appreciate that it's an extra step. So maybe more hands make lighter work. So again, we're almost out of time. I don't want to go over time, but I do want to just work down this little sample script with you. I think it would be very helpful. So of course, the first question is something like, you don't have to do it exactly like this, but would you be willing or able to sit down with your spouse and talk about things and make decisions if you each had a lawyer working with you? Can you be in the same room? Can you stay calm? Can you talk about things if you had help? Okay. Would you be willing to work with a settlement specialist, specially trained lawyer, who's not going to be, pounding her chest and, threatening to go to court and do all this and do that? Would you be willing to work in that context of focusing only on a resolution, only on what's best for your kids? Can you set aside the path forward, be forward looking about this? Okay. If yes, would you agree not to file anything in court while that's going on? Would you agree that you're going to work through this process before you file anything, right? Then do you understand that you agreed to this and it didn't work out? This particular lawyer is not going to file anything in court for you. They can't. They're not going to be able to help you any further if you can't work your case out. Again, I mean, you see there's some repetition in here because sometimes people need to hear a question twice, maybe in a little different way. Do you think that you and your spouse could sit down and discuss issues calmly if you both had a lawyer representing you and were there with you? You kind of need to assess, sort of on a scale of 1 to 10, like how relational these people can be with one another. How, are they going to be able to do what's best for them, but also want what's best for the other party and what's best for the kids? Can they get there? They may not be there on the day you talk to them, but are they open to trying? That's really all we ask for. Would you be willing to work with a divorce coach? That's what we call the therapist, because people kind of have strong reactions to therapist, counselor, mental health professional. We call them divorce coaches. Would you be willing to work with a divorce coach who's a parenting expert to help you work on your parenting plan and to help you manage your emotions as you go through this grief journey that you're on? This is a grief journey. It's hard work, okay? Are you able to disclose all of your financial information? Are you willing? Will you produce bank statements and, whatever? Do you think your spouse could do that? That's where we get into what Monique was asking about, what if they're hiding money? We have our ways of finding that. Can you commit to attending the scheduled meetings, the hours? We're hard on that time. We don't go past that because it's actually 2 hours with the half an hour with the team, 2 hours with the client, and a half an hour professional debrief where we hold one another accountable. But can you commit to 2 hours coming or working hard, sitting, can you set that time aside? Will you show up when you say you're going to, right? And then do you understand that if you commit and don't show up, you're out of the process? So we want them to know ahead of time that we're not playing around, and that if they commit, they have to follow through. So those are the considerations that I think are the most important ones for screening folks. Of course, you've got your domestic violence screening as well that you're going to do. Any questions about talking to people about, are they capable of participating in the process? Any thoughts about that? Anything that you think I missed, knowing what you know now about collaborative and your clients, your typical call-ins?
Dayton again. I think that we have what I call tire kickers. Those folks they come to the car a lot and they're not really gonna buy a car. They're just thinking about it. This may be, because starting especially if I can't offer representation for a divorce for whatever reason, whether it's resources or their case doesn't qualify, whatever, it's pretty daunting as a pro se to go through that process. This may be the middle ground where they're not filing. It's like it sounds to me, and I'm maybe oversimplifying, but it sounds like you're just jumping right to mediation, and from mediation you're trying to come up with an agreement. So this may be an alternative.
Mm-hmm. It's kind of like that. I mean, obviously it's not the same as mediation, but yes, you're jumping right to resolution before anybody's filed anything. That's right. Yep. Yep. I mean, I obviously I think it's the way all divorces should be handled, or most divorces anyway, and we're not there yet. So after 30 years plus of collaborative really being around and people getting trained, and we haven't seen that collaborative practice has become the norm rather than the exception. And so part of the reason that we are doing this access work is to address this notion that this is a client-driven process. People have to ask for it or demand it so that lawyers will get on board. And you have to build it from the bottom up, which is what we're doing here, and the top down. And you just, that's the only way that we're going to make this commonplace in the family law arena, is to hit it. So my practice, I do sliding fee scale for everything because I want every family to have collaborative. And so not all professionals do that. Again, that's a very personal choice that I've made for my life, but that's kind of what needs to happen in order to help word spread about collaborative, that collaborative is a thing. Most people don't even, you say collaborative divorce and they have no idea what you're talking about. So that's a marketing problem. But in any event, we help some folks here, they tell their friends, that that's how it works. It's word of mouth. And so we're just trying to build as many cases as we can and get it out there.
I have a question.
Any
Hi,
last
Pam.
questions about anything?
I was just wondering if in your experience you had noticed if clients that were more sophisticated had a better shot at maybe doing collaborative over the people that are perhaps more lay and perhaps don't have, I don't want to use the term emotionally challenged, but I mean, everybody in divorce usually turns to be a little emotionally challenged because of the circumstances. But, do you find that more people that are more sophisticated are more willing to do the collaborative process over people that maybe don't have?
I don't find that actually. Again, I find that, so we're talking about like emotional sophistication, and then there's the financial spectrum. So like I said, the folks with plenty of money can solve plenty of problems. So those cases in that regard are a little bit easier. But on the emotional side of it, I'm in a super high asset case right now where one party is just very emotionally labile, very angry. She thinks that her worth is tied to her alimony. She doesn't understand or refuses to accept this need versus ability to pay analysis. And that case is going to end without an agreement, sadly, after 7 meetings. And then on the flip side, I've worked with what you would call less emotionally sophisticated people who it's just like they're just thirsty for someone to be kind and respectful to them and to listen to them. And they get in this process and they just drink it in and they blossom and they become completely capable of making really good decisions for themselves because of the way they're being treated. And for me, that's just the most wonderful experience I can have as a professional. It's amazing. That answer your question?
Sorry, I was having an issue with the microphone. Yeah, I guess I'm glad that at least you've had that experience.
Yeah. Yeah. And, I mean, I think what I would say about that is there's no predicting which way it's going to go. It doesn't, there's no, wealth does not really impact emotional sophistication or maturity or ability to participate and make good decisions. That's the bottom line on that.
Pam, I wanted to just I just wanted to ask you, so I've been hearing about collaborative law for some time, and you've been practicing it for a long time. Why do you think it's not more popular than it is? I mean, you mentioned marketing and all that, but I agree. I think that this is the way to do it, but.
Yeah, I'll tell you exactly why, and this doesn't make me a very popular person among the collaborative legal community. The reason is the cost and professionals' unwillingness to consider alternative fee structures for collaborative. So there was an article that came out last year about the average cost of a collaborative divorce, and it was something like $38,000. And the thrust of the article, the thrust of the article was, the title was something like, collaborative process, not just for the wealthy or something. And I read that and I said, you've got to be kidding me. Now, maybe this author was living in Palm Beach County or over in Naples or something, but $38,000 to a family is an unattainable sum for more than 80% of the people that live in the state of Florida. If you look at income statistics in the state of Florida, the median income is well below 50,000, and 75% of Floridians make below 50,000. So if you're unwilling to offer alternative fee structures, you are cutting yourself off from 80% of the potential market, in my opinion. And that's why I have structured my business as I have, because it's almost like you're selling a car, right? But the only thing we're offering is a brand new Cadillac with all the bells and whistles. Well, some families don't need that. Some families don't want that. Some families can't afford that. Some families
need a Toyota.
Yeah, or a 10-year-old minivan with 100,000 miles on it, or and so until as a professional community, we are willing to offer all makes and models of vehicles, I think we're going to continue to have this problem. And the good news is that my work statewide on access, there's a statewide collaborative organization called FACP, Florida Academy of Collaborative Professionals. There's some great resources on their website. We are finally starting to break through, the hard-headed, money-focused people, because people get trained and then they can't get a collaborative case. And they're all upset because they want to do collaborative and they think it's so great. And why isn't everybody doing it? And why aren't I getting cases? And when you say to them, well, if you want a collaborative case, maybe you think about meeting your clients where they need you to, and then you're going to get collaborative cases. And it's a question of, does their desire to do collaborative work outweigh their fear that they're not going to make enough money? And, you know, again, that's a really personal conversation, and people's relationship with money and income is really complicated. And from my perspective, if you know, I work on a sliding fee scale. And so over time, you know, everything works out and I make enough to be okay. Right. And I don't, that's just how I personally look at it. And until more people are willing to do that, I don't think we're going to have the paradigm shift that we're looking for. That's the long answer. And my soapbox, I'll step down now.
Thank you.
Yeah. Anybody else? Thoughts, questions?
I have a question just from the helpline perspective. I'm just trying to gauge based on some of the cases that we get. For example, if we have a client that's calling in and saying that they don't have any children in common, or maybe they don't think they have any property, or there's not a lot to be distributed, or maybe nothing to be distributed, are those not necessarily good candidates to try to refer?
Yeah, those would not need a collaborative process. That's going to be a simplified divorce, no matter how you slice it, and you know, unless there's DV or something like that. But in that instance, I don't think that would make it appropriate for, that factor alone would not make it appropriate for collaborative. Yeah. Good question. Thank you. Julian, how does it work for people who only speak another language? Yes, you asked that before and I saw it and then it went away. Thank you, Julian. So one of the access points that we're working on is people who speak other languages. And obviously we have to put a team together that speaks the language that these folks speak. And that's very, very challenging. I think I could probably do it with Spanish speakers and probably not any other language at this point in time. The bigger problem, and this was one of you all's cases that this happened in actually, was that we did not know that there was a language barrier. And we were in the middle of either the first or the second meeting before the husband. There's a cultural piece to this too, Julian. You know, this was a Spanish-speaking Hispanic couple, and so we were dealing with the cultural piece of the machismo, and she was a little bit reticent to step up, and he was very authoritarian and demanding, and you know, just the typical way that those folks interact with one another in an intimate relationship. And in any event, about towards the end of the first meeting, or it might have been the second, we're talking about something kind of complicated, and he all of a sudden starts speaking to her across the table in Spanish. And we all look at each other, and she says to me, he's asking me to explain it to him. And so then we have the issue of, well, we don't know what she's saying back to him. You know, even those of us that speak a little bit of Spanish, we don't know exactly what she's saying back to him, or if she's explaining it correctly, or, you know, now we've got a problem. And we did work through that one, but not knowing that there's a language barrier is a bigger problem, really, to my way of thinking, than trying to put a team together that speaks the language of the clients. So does that answer your question? Julian, are you going to talk to us?
You're still muted.
Can you hear me?
Yes, now I can hear you.
Okay,
yes.
awesome.
Yeah.
Sorry, I had the mic all the way up.
I see that.
So, yes, it does answer, but then you have within that culture, you also have the subcultures that go below. For example, you have a husband who is from Colombia and a wife who is from Puerto Rico, or vice versa. So those two cultures, although they have a very similar language and similar types of food, the attitude is totally different.
Yeah, you're exactly right. It's really fraught, and you know, part of what we're doing statewide is a diversity initiative to try to get more diverse professionals involved. We really are struggling, and I don't think it's just us in Florida. I think it's in many, many places. They're struggling to have the professionals with the cultural diversity that we would like to see. And sometimes what we do is we'll just consult an expert. You know, we'll figure out what cultures we're dealing with, and we'll find somebody that can help us, right? If there's not a language problem. So yeah, great point. It's absolutely true. It's really important, that cultural piece, really important. Anything else?
Pam, very quick question. With regard to some of the clients that we do see on the helpline, some of our clients may be served with, let's say, a divorce petition, but I mean, they're in the very introductory portion of the process. Do you ever find any impediments or any hurdles when the other side is actually represented? And, you know, if we're going through the spiel of, would you feel comfortable? Do you think your spouse would feel comfortable? And the divorce, like the other attorney who may or may not have familiarity with collaborative divorce.
Yeah, thank you for bringing that up because it happens. First of all, in terms of the court process, it's no problem. The statute allows you to file a motion to stay, and the judge stays the litigation until the collaborative process is terminated. In terms of dealing with a lawyer who's already on board, I never say no to that. What I do is I tell the person that we're screening, like, his lawyer has to agree to this. So I will ask. And I use it as an opportunity to introduce yet another lawyer to collaborative process. And I explain it to them and I say, hey, are you willing to do this case collaboratively? And sometimes they say yes, and sometimes they say no, and sometimes they're really, really hard to work with, and sometimes they're amazing. And I know I have a new collaborative practitioner ahead, so that is not an impediment at all. It may end up being one at the end if they refuse, right? So there may be some administrative back and forth, sadly, for you guys, but always willing to try.
And just to be clear, to piggyback on that, that attorney would have, that opposing party attorney would have to agree to withdraw if the collaborative case did not settle.
Yes. And sometimes that's what appeals to them about saying yes to collaborative. They've got a client on their hands that they're like, hey, why did I take this case, right? And so it's kind of out to them sometimes.
And do they have to be trained in the middle of it in order to qualify to be collaborative? Okay.
If I'm willing, or the other collaborative lawyer is willing to work with them as an untrained professional, that there's no ethical violation to do that. It's fraught, it's dangerous, but there's no ethical violation. Okay, Julian had asked about what I call shadow advisors. People who are chattering in the ears of our clients, telling them what to do and what the law says and what. So there are shadow advisors in almost every divorce case, no matter what process you're using, there are shadow advisors. And they are a real challenge because every divorce is different. And so what these people are telling them may not apply to their situation. It may be bad legal advice. You don't know what they told their lawyer to elicit that advice that they're now sharing. You know, it's craziness. In collaborative, it's reduced a little bit because participants cannot consult with a litigator during the collaborative process unless they disclose that. So if the shadow advisor is another lawyer that somebody's going and getting a second opinion, that doesn't happen in collaborative. Now, they may come and say, listen, I just need to talk to a litigator, and the team as a team may say, okay, who is it? Why do you want to do that? And off you know, we allow that. But the other thing that happens in collaborative is the divorce coach is really able to explain in a way that the lawyers can't why it's a bad idea to listen to those shadow advisors. And you can never overcome it completely, Julian, especially if one of the shadow advisors is paying for the divorce. That wouldn't be the case in a pro bono case, but it is in many, many other cases. You know, dad is paying for it or mom is paying for it. And so the client feels like they have to make the deal that mom or dad wants them to make. And it's just a case by case basis. You have to just deal with it. You're nodding, so I think that I answered your question. Okay. What else do you guys want to talk about? We're way over time, but I'm happy to stay on as long as you will have me.
One last quick question for you. You mentioned the admissibility piece all the way at the beginning and how nothing is admissible. In
Correct.
terms of like, I keep going back to the mental health, you know, counselors and things like that. Do you ever run into situations where there are kind of, I don't want to say allegations, but essentially it comes up where there's some sort of like, let's say a sexual abuse of a child or something like that, you know, like how is that handled
Okay,
in this
so
process?
as you all know, lawyers and mental health are mandatory reporters. And so there can be no discretion if there is a disclosure of sexual abuse of a child, to use your example. And there are, you know, you guys know the exceptions of confidentiality. They absolutely apply in collaborative process. Yeah.
Okay.
Yeah. And we talk about that. They talk about that with them at the beginning of the consultation.
Okay.
Yeah. Yeah. Mm-hmm. So many good questions, you guys. This has been so much fun for me. I don't know about you guys, but I had a good time.
It's been really great for us as well, Pam. This has been really, really especially enriching to hear this perspective. And I know for myself, this is, you know, my first time hearing about collaborative divorce. So I just want to take the time to say thank you for willing, you know, to share your nuggets of wisdom and your training. It's been really, really helpful. And I think we'll be able to send you more cases in
Yay.
the
Okay.
future.
Well, any of you, please feel free to reach out to me if you have any questions about anything or follow up, or I'm always, obviously, always happy to talk about collaborative process. And so thanks for giving me the forum to spread the good word. Thank you so much.